Welcome to This Week in Education Law School Administrator's Guide, where I share up-to-date court decisions that shape our educational system. This is episode 27. Today, I'll introduce the U.S. Supreme Court's decision on affirmative action and its far-reaching implications. Both Harvard University and the University of North Carolina use race as part of their student admissions policies. We'll first take a close look at the policies, followed by the Supreme Court's opinion. We'll then discuss the implications of this landmark decision. At Harvard, each application for admission undergoes an initial screening by a first reader who assigns a numerical score in 6 categories: academic, extracurricular, athletic, school support, personal, and overall. The overall category is a composite of the other 5 categories and considers the applicant's race. Next, regional admissions subcommittees review applications from their assigned geographic areas. They make recommendations to the full admissions committee based on their evaluations, and they take an applicant's race into account. Then, the full admissions committee, consisting of 40 members, begins their deliberations. During the committee's discussions, they consider the racial composition of the applicants. The goal of the process, according to Harvard's Director of Admissions, is to ensure there is no dramatic drop-off in minority admissions from the prior class. Applicants who receive a majority of votes from the full admission committee are tentatively accepted. The racial composition of the tentative applicant pool is disclosed to the committee. The committee's consideration of the racial composition of the potential class may indirectly influence their admission decisions. The final stage is referred to as the lot, where the list of tentatively admitted students is narrowed down to form the final class. To decide which applicants will be admitted to Harvard and which will be cut, the admission decision is made based on 4 criteria: legacy status, recruited athlete status, financial aid eligibility, and race. Throughout the Harvard admission process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. The University of North Carolina has a similar admission process. Here is the basic structure: an initial review by an office reader who takes into account the applicant's race among other factors, and a follow-up by a committee of experienced staff members who either approve or reject the reader's recommendation. Here is where things get controversial. The petitioner, a nonprofit organization called Students for Fair Admissions, claims that the race-based admission policies at both universities are in violation of the Equal Protection Clause of the 14th Amendment. Students for Fair Admissions has taken their case against both schools to court, asserting that the use of race as a factor in admission is unconstitutional. In a 6-3 decision, the Supreme Court held that both admission policies violate the Equal Protection Clause of the 14th Amendment. Chief Justice John Roberts delivered the majority opinion of the court. The majority of the Supreme Court reached this decision for 3 reasons. First, any policy that treats people differently based on their race needs to meet 2 requirements of strict scrutiny. In my earlier video discussing the 3 levels of review used to determine whether a policy is constitutional, I mentioned that race-based policies automatically trigger strict scrutiny, which is widely recognized as the most stringent level of review. In this case, race-based admission policies fail to meet the requirement of strict scrutiny. The first requirement of strict scrutiny is that the race-based policy needs to serve a compelling interest. Harvard University argues that their race-based admission policy serves 4 interests: training future leaders in the public and the private sectors, preparing graduates to adapt to an increasingly pluralistic society, better educating its students through diversity, and producing new knowledge stemming from diverse outlooks. Similarly, the University of North Carolina argues that their admission policy serves 5 interests: promoting the robust exchange of ideas, broadening and refining understanding, fostering innovation and problem solving, preparing engaged and productive citizens and leaders, and enhancing appreciation, respect, empathy, cross-racial understanding, and breaking down stereotypes. The Supreme Court reasoned that while those goals are commendable, they are too vague for evaluation. How many fewer leaders Harvard would create without racial preferences, or how much poorer the education at Harvard would be? We don't know whether those goals are met. Neither do we know whether a specific mix of minority students, like the certain racial composition of students Harvard has been trying to maintain, can truly produce engaged and productive citizens or effectively train future leaders. The two universities also fail to justify the methods, which are race-based admission policies, are connected to the goals they aim to achieve. To diversify student body, both universities characterize the racial composition of their classes into 6 categories: Asian, Native Hawaiian or Pacific Islander, Hispanic, White, African American, and Native American. Those categories are overly broad, as they group together all Asian students without distinguishing between South Asian and East Asian students. Other racial categories, like Hispanic, are arbitrary and undefined, reflecting the changing labels and evolving cultural norms surrounding Hispanic identity. Moreover, certain racial categories, such as applicants from Middle Eastern countries, are under-inclusive. It remains unclear how assigning students to those overly broad or under-inclusive racial categories and making admission decisions based on them truly advances the claimed educational benefits. For example, by focusing on underrepresentation, the universities would prioritize a class with 15% of students from Mexico over a class with 10% of students from many Latin American countries, solely based on the higher number of Hispanic students in the former. If so, does the use of those opaque racial categories promote or undermine the university's goal of better educating its students through diversity, promoting the robust exchange of ideas, and broadening and refining understanding? Second, the race-based admissions policy failed to comply with the principles outlined in the Equal Protection Clause that race may never be used as a negative and that race may not be operated as a stereotype. However, in this case, the university's consideration of race led to a decrease in the admission of Asian Americans and white students. The universities acknowledge that their student racial makeup would significantly change if race-based admissions were abandoned, and that race is determinative for at least some of the admitted students. How else but negative can race be described if, in its absence, members of some racial groups would be admitted in greater numbers than they otherwise would have been? The equal protection of the law is not achieved through indiscriminate imposition of inequalities. Moreover, the race-based admissions policies operate on the belief that minority students consistently express a characteristic minority viewpoint. However, members of the same racial group do not necessarily think alike. Treating people differently based on their race demeans their character, dignity, and worth, going against the core purpose of the Equal Protection Clause. When the university admits students based on their race, it engages in offensive and demeaning assumptions that people of a particular race think alike. This stereotyping perpetuates injury, contradicting the principles and goals of the Equal Protection Clause. Third, the university's admission policy do not have a clear logical endpoint. The universities argue that their race-based admissions policies will end when there is meaningful representation and meaningful diversity on college campuses. However, the concept of meaningful representation lacks a precise numerical benchmark or specified percentage. Both Harvard and the University of North Carolina use the racial composition of their classes as a basis for admission decisions and closely track the breakdown of racial identities to ensure a certain level of racial diversity. This focus on numbers is evident in the admissions results, where specific racial groups maintain consistent representation over the years. However, these approaches face a well-established problem. Outright racial balancing is patently unconstitutional. The core principle of the Constitution's equal protection is that the government must treat individuals as unique individuals, not solely as representatives of a racial, religious, sexual, or national group. When the universities promise to end the use of race only when certain percentages of different racial groups are admitted, their admission policies effectively ensures that race will always be a relevant factor and that the ultimate goal of eliminating race as a criterion will never be accomplished. In fact, Harvard openly admits that its race-based admissions policy does not have a specific endpoint. The University of North Carolina has not set an expiration date and has suggested that they may soon use race to a greater extent than it currently does. The two universities' race-based admission policies do not align with the Equal Protection Clause's promises because they lack clear and measurable objectives for the use of race. Race is used as a negative for some racial groups. They reinforce racial stereotypes, and they do not have clear endpoints. For the reasons here, the Supreme Court held that the policies violate the Equal Protection Clause of the 14th Amendment. Justice Sonia Sotomayor, Alana Kagan, and Ketanji Jackson disagreed with the court's decision. Justice Sotomayor wrote, "The 14th Amendment does not impose a blanket ban on race-conscious policies. Society remains inherently unequal. Racial inequality runs deep to this very day. That is particularly true in education, the most vital civic institution for the preservation of a democratic system of government. Only with eyes open to this reality can the court carry out the guarantee of equal protection." Justice Sotomayor also argued that the two universities' race-based admission policies met two requirements of strict scrutiny. They serve a compelling interest, which is obtaining the educational benefits that flow from a racially diverse student body, and they are narrowly tailored. What are implications of this Supreme Court ruling? First, the court ruling has broader implications beyond colleges, as similar issues exist in competitive programs in elite high schools. As education policies and administrators work to improve racial diversity of student body, caution needs to be exercised when using proxies or other criteria such as socioeconomic status, geographic zones, or diversity statements. The key issue is intent. It's important to look at whether educational institutions have a specific racial composition in mind when defining socioeconomic status or other proxies. As schools develop new criteria for admissions, there will be paper trail showing their efforts to hide racial preferences. There will be ongoing scrutiny to identify any praxis or pretext used to achieve racial balancing. It's important to ensure that people are judged based on their individual qualities and abilities rather than their race. Another important point is that colleges and universities can still consider a student's essay about overcoming adversity related to their race as a factor in admissions. However, it's important to monitor whether emphasis is given to one racial group over others when considering essays. Some college and elite programs in high schools are dropping standardized tests and making admissions decisions in an opaque manner. This may lead to litigation if it is a pretext to implement racial preferences indirectly. One aspect highlighted in the litigation is the manipulation of personality scores to systematically disadvantage Asian applicants. The court's ruling does not directly apply to employment policies and corporate diversity, equity, and inclusion programs or other areas beyond college admissions. Employment cases are governed by different Supreme Court precedents under Title VII of the Civil Rights Act, which prohibits employment discrimination based on race, color, religion, sex, and national origin. But the Supreme Court's ruling will have ripple effect on how organizations handle their hiring, promotion, and termination practices. It's still a good practice for employers to actively seek qualified candidates from diverse backgrounds and then choose the most talented candidates. It's crucial to ensure that employment decisions are made based on candidates' qualities and abilities rather than race, color, religion, sex, and national origin.